Landlord-tenant law is an important subset of real property ownership and use that we need to cover now. So the landlord-tenant relationship is a contractual arrangement in which the owner of real property allows another to have temporary possession and control of the premises in exchange for consideration. So if you are renting an apartment or house, this is the subset of law under which you're operating. A lease is the agreement that gives rise to the landlord-tenant relationship. The lessor or landlord is the owner of the property, and the lessee or tenant is the person to whom the lease is given. There's 5 necessary elements to create a landlord-tenant relationship. First, there must be consent of the landlord to the occupancy by the tenant. Second, there has to be transfer of possession and control of the property to the tenant in an inferior position to the rights of the landlord. 3, the right by the landlord to return the property, called the right of reversion. The creation of an ownership interest in the tenant, known as the leasehold, either an express or implied contract between the parties that satisfies all the essentials of a valid contract. So you probably learned that in Business Law 1, but mutual assent, competent parties, consideration, and a lawful purpose. A lease gives an interest in real property and transfers possession of that property. A license is different. A license gives no property right or ownership interest in the property. It just allows the licensee to do certain acts that would otherwise be a trespass. A lodger is one who has use of property without actual or exclusive possession of it. So this is a type of licensee. The leasehold estate or the tenancy is the term that encompasses the interest conveyed by a lease. And there's 4 different kinds of leasehold estates. There's a tenancy at will, a tenancy for years, a periodic tenancy, and a tenancy in sufferance. So first, a tenancy at will is an ownership interest in real property for an indefinite period of time. No writing is required to create it, and it may be terminated at the will of either party by giving proper notice. And this is if you rent an apartment, for example, and you may have an initial term of your lease, and then after that, it may go month to month. Once it goes month to month, it's a tenancy at will. And so to get out of that contract, you have to give notice, and the amount or length of notice is going to vary from state to state. It can range from the time between rent periods to 30 days written notice from the next day that rent is due. The rule generally followed is that a tenancy at will comes to an end when the property is sold by the landlord to a third party. The notice required by state law must be given to the tenant in any event. A tenancy for years is an ownership interest in real property for a definite or fixed period of time. So, and here when we're saying an ownership interest, it's not the fee simple estate, right? I don't own the asset, but I own the right to use the asset. That's what a lease ownership interest is. So in a tenancy for years, it's a right to use the real property for a definite or fixed period of time. So in some states, that tenancy for years may be oral if the term's shorter than a year. Otherwise, it must be in writing. Other states require all tenancies for years to be in writing. A tenant who remains in possession of the premises at the expiration of the term with permission of the landlord, but without a new lease, is a tenant at will in some states, and they are in Texas. In other states, the tenant is known as a periodic tenant. So a tenancy for years is, in most normal leases of an apartment or home, you have a tenancy for years at the beginning. So maybe you have to agree to lease for a year, and then after that it reverts to a tenancy at will. A periodic tenancy, or tenancy from year to year, is a fixed period tenancy that continues for successive periods until one of the parties terminates it by giving notice to the other party. And then a tenancy at sufferance is when tenants wrongfully remain in possession of the premises after their tenancy has expired. This often comes about at the expiration of the term of a tenancy for years. The essential requirements to have a valid lease are a definite agreement as to the extent and bounds of the leased property, a definite and agreed term of the lease, and a definite and agreed price of rental and manner of payment. Some large communities have passed rent control laws. You may have heard of these in New York, right? They limit the amount of rent and they often contain procedures that must be followed before tenants can be evicted. So these aren't really common in Texas, but they are common in large, expensive states. So New York, for example, some in California. Some states have done away with rent control laws altogether, though. In a rent, it's common to have a required security deposit. So it's generally it's generally either a whole month's rent or a portion of a whole month's rent. And then landlords often require that or the last month's rent or both to be paid at the beginning of a tenancy. The deposit is going to protect a landlord against damages to their property as well as non-payment of rent. Some leases give an option to renew the lease at the end of the term. If that is the case, the new lease is going to be on the same terms as the old one, with the possible exception of an increase in rent. A lessee may, if the lease provides, be given an option to purchase the property. This is an agreement by the lessor to sell the property to the lessee for a stated price. To exercise the option, the lessee must notify the lessor within the time period stated in the lease of the decision to purchase the property. Sometimes a tenant may not want to stay in their property or stay in their lease for the entire term of the lease. In that case, they might want to assign or sublease. An assignment occurs when the interest in the leased premises is transferred by the lessee to another person for the balance of the term of the lease. And then a sublease or underlease is the transfer for a part of the term but not for the remainder of it. So this is allowed unless the lease states otherwise. And many leases do either prohibit assignments and subleases or require approval for assignments and subleases. A landlord has some duties when they lease their property. A landlord can't discriminate on the basis of race, creed, color, or sex. And in most states, a landlord may restrict rentals to persons without children. There are also certified communities, retirement home communities, that are allowed to restrict rentals based on age, but it has to be a certified retirement community. The landlord has to abide by the warranty of habitability, which means that the premises are fit for human habitation, and there are no defects vital to the use of the premises for residential purposes. And many cities have adopted ordinances to protect tenants from unsafe or unhealthy conditions created by a landlord's refusal to make necessary repairs. Building inspectors, health authorities, and other public officials are empowered to make inspections and demand improvements when they're contacted by dissatisfied tenants. In many cases, ordinances permit the tenant to cease payment of rent for the period during which the landlord fails to make repairs or improvements as needed. The landlord must deliver quiet enjoyment, which is the right of a tenant to the undisturbed possession of the property. The landlord is not allowed to interfere with the tenant's rights of possession as long as the tenant abides by the conditions of the lease and those imposed by law. All right, so if a tenant is not abiding by their duties in the lease, they might be evicted. And there is actual eviction when the tenant is physically deprived of the leasehold, but there's also constructive eviction when the tenant is deprived of something of substantial nature that was called for under the lease. And there can be rightful or wrongful eviction. So especially under constructive eviction, if a tenant is deprived of something that makes the lease valid, then they have been constructively evicted and they can file a lawsuit against the landlord. The tenant has the duty to pay rent to the landlord and observe the valid restrictions contained in the lease. Leases are allowed to impose duties of all kind as long as they're legal and don't deny a tenant's constitutional rights. Failure to abide by the restrictions agreed to at the time of the signing of the lease gives the landlord the right to seek eviction of the tenant. And leased property may bring up tort liability if a person is injured on leased property. The one who's in control of the part of the premises where the injury occurs usually is responsible if the injury was caused by that person's negligence. The landlord, for example, is responsible for injury to others that may be caused by a defect in the common areas, such as hallways and stairways. Although landlords are not guarantors of the safety of persons in a building's common area, They're not free to ignore reasonably foreseeable risks of harm to tenants and others lawfully on the premises. Landlords must take reasonable steps to guard against foreseeable criminal acts of third parties. And if tenants don't pay, a landlord may begin eviction proceedings. States today don't allow landlords to use force to evict tenants. Instead, they must make use of statutory remedies that are available to them. Some states do, however, recognize the right of landlords to enter wrongfully held premises and take over possession if it can be done peacefully. The remedy provides landlords with a quick method of regaining possession of their property and protects tenants from being ousted by force and violence. There are strict notice requirements that must be followed by the landlord, after which both parties are given their day in court. If a forcible eviction becomes necessary, it's going to be done by the sheriff under the supervision of the court. Ejectment is the common law name that was given to the lawsuits brought by the landlord to have the tenant evicted from the premises. An unlawful detainer is a legal proceeding that provides landlords with a quick method of evicting a tenant. It's also called summary process, summary ejectment, forcible entry and detainer, and dispossessory warrant proceedings.